Sorry, we're slightly late. Our electronic systems, timekeeping systems don't seem to be all they might be. Yep.
My Lord, I will nonetheless endeavour to move on with as much speed as I can. My Lords, I'm going to address first of all issue 2, and your Lordships will remember that my friend took you to paragraph 80 of his case, where he showed you his one qualification to the agreed position before the Court of Appeal as to how one might address questions of allowability in the context of Rule F. And he showed you the qualification, something derived from Stagline and Foscolo Mango, as to how one might look at reasonableness, a course of action which a prudent person controlling the voyage at the time might adopt, having in mind all the relevant circumstances and so on and so on. What he did not draw so much attention to was that in paragraph 79 of his case, 79 and 80, he effectively adopts, in the same way that we adopt, the approach of the Court of Appeal to the question of how reasonableness is to be addressed for the purposes of Rule F. Now, my Lords, this is, he shows you a short reference to the Court of Appeal's judgment at paragraph 79 of his case. Can I ask your Lordships to look at the judgment itself at page 217 of the bundle?
Yes.
Pick it up at 73. Sorry, paragraph 73, page
Yes.
217.
We got it. Yep.
And now, Lord Justice Hamlin is quoting from the judge. He expressed his conclusions as follows: despite the problems canvassed by the textbook writers, there is little room for doubting the proposition that on a true construction of Rule F, the hypothetical alternative course of action must meet the requirement that it was reasonably incurred. This, of course, in the context of a Rule A case, if it's to be allowed in general average. What the problems canvassed by the textbook writers show is that the requirement that the expense, if it had been incurred, would have been reasonably incurred, must be interpreted and applied with a sufficient degree of latitude to give Rule F practical effect. What the judge had done was to reject our, if you like, Bejailer approach to the question of the Hudson conundrum, how to resolve the Hudson conundrum. But here is his mitigation of it, that there must be a sufficient degree of latitude to give Rule F practical effect. And then paragraph 74, Lord Justice Hamlin agrees with that approach. So it has been the approach both of the judge and of the Court of Appeal. It's the approach that I advocate, and it's the approach my learned friend accepts, that there must be a sufficient degree of latitude in the assessment of allowability or reasonableness when we're referring to a Rule A, to give Rule F practical effect. Otherwise, the Hudson conundrum comes in with full force, and it will be difficult to persuade anyone that an avoided course was necessary. How could it be if it's been avoided? It will be difficult to persuade any court that a reasonable course was not taken at all because, well, ignoring the fact that there was a more reasonable course to take. This is the Hudson conundrum, and there must be some mitigation or solution to it. Now, my lords, if I were looking at this question and the admission of the payment of $6 million paid in ransom purely as a Rule A case, if we had paid $6 million and I came to the court and said, well, that's reasonable in all the circumstances, I might be in some difficulty for the reasons my learned friend has ably set out. What would happen in those circumstances is that the court would allow the ransom up to the amount that was reasonable. That's Australasian Shipping Company and Green, which is in your bundles, but never mind about that. The principle is you allow the general average sacrifice or expenditure that is allowed under Rule A up to the amount that is reasonable. It's not a total forfeit if you have incurred an unreasonable amount. But, my lords, that's not the question we're faced with at all. It's not a Rule A case, and it is, I respectfully suggest, not helpful to consider it so. We've made a number of points in our case, particularly at paragraphs 98 and 99, in answer to the policy consideration arguments that my learned friend addressed. And we say there, on the basis taken by the Court of Appeal, the finding of the Court of Appeal on Issue 2 simply means that a shipowner or other negotiating party need not fear that its negotiating costs will not be allowed, provided it would be within the applicable bounds, that's the latitude extended bounds of reasonableness, not to negotiate the ransom. The latitude given by the courts below to the allowability of the voided costs relates only to Rule F. It is necessary to extend that latitude to give Rule F practical effect, to avoid or mitigate the Hudson conundrum. It is not necessary to decide what latitude should be given to the requirement of reasonableness in Rule A. Now, that is the position. We are trying to mitigate the Hudson conundrum, and the solution taken by the courts, both courts below, is to assess the facts by reference to the same legal standard, a broadly extended, latitude extended test of reasonableness. They have both done it in exactly the same way by reference to the same legal standard, and they have come to the same answer. And I therefore do make the submission, which I make in my case, that one must give some respect to the margin of appreciation or
This is for the purposes of Rule F recovery.
My lord, Rule F, yes.
So, do you accept that if they had incurred the avoided expense, the court under Rule A would have decided objectively, without any such margin of appreciation, whether it was reasonable?
My lord, it's not this case.
No, but I'm asking the question.
You're asking me whether to pay $6 million in the
Yes, supposing the court came to the conclusion that if the $6 million had been paid, or if more than the value of the ship and cargo had been paid under Rule A, that would have been unreasonable, right? That would be the test, wouldn't it?
Yes.
The court would assess. There wouldn't be any margin of appreciation then.
No.
Right. So you're saying that although you couldn't recover the $6 million under Rule A, if you substitute for it some other expense by negotiation, you can recover that as long as it's less than 6 million.
Up to the saving, not 6 million. It's the saving.
Sorry, as long as
saving. It's 4.15.
As long as it's less than the saving.
Yes.
Yeah.
4.15.
Right.
I mean, why, if the court were looking at the maximum reasonable ransom
Yes.
under Rule A,
Yes.
without any question of substituted expense, would it necessarily conclude that the reasonable ransom payable was a precise figure?
No.
In a situation of this kind, another possibility is that the court would say anything between, to pluck figures out of the air, 1 million and 4 million would come within the range of reasonable outcomes in dealing with a negotiation with a group of criminals, great precision about how much you can get away with may be difficult to achieve.
I quite understand the point your lordship makes. Yes, there may be a range.
I mean, whether you call it a margin of appreciation or not, but a reasonable ransom is not necessarily a precise figure. It may be a figure lying within a range.
My junior reminds me, of course, of the gratitudine, which we have cited in our case, which says that the master has authority, circumstances of emergency, to hypothecate or ransom the entire value of ship and cargo.
It doesn't follow that he'd be reasonable to exercise that.
Well, of course, reasonable. This is agency of necessity. He has to act reasonably, and if that law is still good, then it would be reasonable within the bounds of his authority to ransom the entire amount up to its full value.
Right, well, now on my lord's point, which is accepted, why are you talking about the Hudson conundrum at all?
Well, my lord, because we have to, it's the avoidance of...
No, but the Hudson conundrum must become irrelevant.
Yes,
and, everybody accepts that if under Rule A you could categorise the expense avoided as reasonable,
yes,
then there's no problem under Rule F.
No, my lord, absolutely
Yeah,
right.
so
Once
the
one
Hudson
gets
conundrum
there,
only arises on the opposite postulate, doesn't it?
yes, if it's
only
only
arises if
There's a single figure.
if it's unreasonable.
well, if it would be unreasonable under Rule A, and you then ask, well, how on earth can be recoverable under Rule F, although you have adopted the alternative course and saved, incurred the extra expenses simply because it was unreasonable under Rule A.
Well,
It may be that the word allowable in F
yes,
is a reference to allow in C.
no, my lord.
After all, allowable is not found in A. Is general average allowable as a general expense, which would be allowable as a general average in F, merely dealing with the type of expense, rather than an expense which falls within A? Because the word allowable, as I said, isn't in A, it's in C. And is it therefore actually dealing with types of expense, rather than concerned with their reasonableness?
In the first sentence of C, allowed.
Yeah, that's where you find the word allowed.
Yes, allowed.
You don't find it in A.
Yes.
And therefore I wonder whether
Well, I
F
wonder
is...
if that's not a possible way of approaching it.
Well, it does avoid the Hudson conundrum.
Yes.
Because what about the last words, but only up to the amount of the general average expense avoided?
Yeah, that then brings you into A.
Yes, that's right.
But it gets you home as the expense generally.
Well, as your lordship rightly says, the word in F, in Rule F, is allowable as general average. And it may be that it's looking at it in terms of allowable in principle.
Yeah, that's what I mean.
Of the sort
Then
of
you're
type
saving, as Lord Nance says, and
Yes.
when you look at the saving, you can't get more than what would have been a reasonable sum under A, because
Yes.
A has to be reasonable.
Yes. Well, that's certainly an approach. My lords, the idea of a court, however, addressing what is a reasonable ransom, well, it may be ultimately unavoidable, but it's a most unedifying exercise in that one is weighing up values of ship cargo against risks, real risks to crew. One shouldn't underestimate the suffering experienced by captured seafarers in cases of Somali piracy. Some have died, happily, not that many, but their experience of captivity, which may have lasted for many months, is certainly not a comfortable one. The idea of trying to assess what is a reasonable ransom, how much you should pay, and how long you should choose to keep seafarers in captivity, is a very awkward judgment for any court.
Well, that's not a reason, presumably, for not making that judgment, but it may be a reason for giving a range.
My lord, no. Ultimately, it may be unavoidable because even on the approach taken by the courts below, there has to be some upper limit on the latitude of reasonableness, so it may not be ultimately avoidable. And indeed, my lord, we focused very much on the initial ransom demand for obvious reasons. But Mr. Madge's point, of course, needs to be thought about as well. In the process of a negotiation, there may come a point, even if the initial demand is not one that could reasonably be met, there will come a point at which the demand is within the bounds of reasonableness. And at that point, of course, one has potential for substitution of expense. If the ship owners go on incurring running costs in order to get it below, even further down than the upper bound of reasonableness, they're in a case of substitution. But it's a very difficult and awkward analysis for a court to undertake, to say, oh, well, yes, now 6 million was a bit steep, but we think once the pirates had come down to 4.5 million, it was perfectly possible to settle on that basis. That would have been reasonable, and therefore the costs incurred between 4.5 million and 1.85 million are in substitution. My lords, it's a very uncomfortable approach. Now, my lords, I realise I've used quite a lot of my time. It's gone rather quickly.
It always does when you're enjoying yourself.
My lords, we have very considerable objections to the use made of the experience of the average adjusters and what they said in 2012 about their experience of the of Somali piracy. And partly, of course, my lords, we say that because their experience and of what is done and what is reasonable is all about Rule A, if you like. Forgive me, I just find my note. They have no experience of what would be allowable within the broad limits of reasonableness under Rule F. They have no relevant experience of that question, the Rule F question. And that, as my learned friend says, is the relevant question. That is common ground. My lords, perhaps now is the time to remind you of Mr. Corner's observation in the RHL press release, the last document in your lordship's bundles, where he observes that in absolute terms, quick payment of a first ransom demand to recover ship and crew while minimizing the period of danger to both is impossible to argue against. As I say, that's a submission that informs our approach to issue 2, Mr. Corner's thoughts that it's impossible to argue against quick ransom and release of ship and crew. And we don't think, therefore, that the experience of the average adjusters formed by 2012 is terribly informative, terribly helpful. But if we are involved in some sort of factual assessment of what was reasonable in January 2009, I do need to take your lordships back to January 2009, which was the relative infancy of Somali piracy. There was a good deal less experience then of how piracy incidents would turn out. Really, the upsurge was in the middle of 2008. That's when Somali piracy really took off, and vessels were increasingly seized and held to ransom. So by 2009, there wasn't much experience of how things would turn out. And reference to an untested statement of experience from 2012 doesn't really carry things very much further forward. My lords, there are other features to, if we were to be looking at the position in 2009, the beginning of 2009, there were other features of the environment at that time which might have made a ship owner extremely nervous. There had been 2 resolutions of the UN Security Council at the end of 2008, which had expressly authorized cooperating navies cooperating with the Yemeni government, to enter into the territorial waters of Somalia and take all necessary means to suppress acts of piracy. There was an increasing militarization of the situation and an increasing risk that the vessels might be, attempts might be made to rescue them militarily. Now that's another risk that a ship owner might have been concerned to avoid in 2009. The trouble is, once the vessel is in the hands of the pirates, anything may happen to it. It may be used as a shield in another piracy situation. It may be taken as a mothership to support skiffs out at sea. It may come up against any number of risks. It is quite unquantifiable. These are all incommensurables, and it's extremely difficult to see how one can reach a conclusion based on the experience of some average adjusters in 2012, taking no account of what the real position was in 2009. Now, my lords, we didn't put in expert evidence, but then neither should the respondents be able to refer to untested opinion evidence either.
The onus must be on you, though, to bring yourself within Rule F.
Yes, we accept that. Well, subject to this, my lord, this case is actually a claim for breach of contract, but it's a claim for failing to have the adjustment drawn up in accordance with the relevant rules.
So the adjustment doesn't have any evidential value. You've got to establish the adjustment, haven't you? Well, I'm afraid.
My lords, the adjustment has some evidential value, but
it's not contractually agreed to be binding.
no, it's not. It's evidential, if anything.
It's not contractually agreed to be evidence.
Certainly. Well,
at best, it's only evidence of the opinion of the person who drew it up.
That
It may or may not resemble the
there
opinion
are, of course,
the
some of
judge.
the documents attached to it are evidence of the facts stated in them, but your lordship is quite right, of course, in terms of yes. Anyway, now...
But why is it a breach of contract claim? Why isn't it simply saying you can't levy general average?
My lord, because there had been payments on account, and the claim was for damages, interestingly, for having miscalculated the amounts due.
Seems very odd.
It
seems like
my lord, it's all in,
to recover monies overpaid.
it's all in the core bundle.
Yeah.
It's all in the core bundle. The
Analytically, it's probably a debt, isn't it?
Yes.
I don't think it makes any difference to the resolution of this appeal. But
My lord, I've outlined the difficulties with the Hudson conundrum. The common ground that has been established in relation to how it is to be resolved, and the fact that both courts applying the same test in exactly the same way have, on the same facts, although for slightly different reasons, come to the same conclusion. I do invite your lordships to leave it there. If you want to look at it another way, the Bejela approach of Lord Justice Hoffman, my friend's best point is the passage at the top of 422 in the judgment, of Lord Justice Hoffman, where he says, that is to say, Rule F, does not require one to suppose that the circumstances in which the owner made his choice were different from those that they actually were. And that is said to support the notion that the solution that Lord Justice Hoffman espoused in relation to Rules 14 and 10 does not operate where Rule F comes into play. My lords, we find that passage Delphic and difficult to understand, to say the least of it, because at this stage of the proceedings in the Bejela, the difficulty appeared to be that Rule 10 allowed no mitigation of the requirement of necessity in incurring the costs that had in fact been avoided by undertaking temporary repairs. Rule 10 said those avoided costs had to be necessary for the safe prosecution of the voyage, and the problem that appeared was that they were not necessary for the safe prosecution of the voyage because temporary repairs had been undertaken and the voyage had been completed without incurring those expenses. That was the problem with Rule 10. It imposed a test of necessity if the expense was to be allowable, and it didn't seem possible to get past that. What Lord Justice Hoffman did in order to save Rule 14 from complete, lack of utility, was to say one must make assumptions for the purposes of allowability under Rule 10 that the avoided course could not be, the actual course taken could not be performed. And on that basis, one could make a conclusion that the course not taken had been necessary. Now, one is working with paradoxes, if you like, here, or conundra. It's the same conundra in my submission, both in relation to Rules 14 and 10, as arises in relation to Rule F and copious other rules. It's a question of the rule of allowability. And in my submission, the solution found by Lord Justice Hoffman is a perfectly respectable and indeed commendable one, and provides a solution here as well in what is exactly the same difficulty. Although we have a rule of reasonableness, which is would be the basis of allowance. My Lords, the only other thing that I need to address, I think, at this stage is the question of what is meant by extra. And we're rather cross that this point has arisen because the judge found that the expenses here incurred were extra expenses, and he said it twice in his judgment, which your Lordships will find in the core bundle at tab 4. Sorry, it's 8.4, 8 sub 4. Lordships look at page 240 of the bundle, paragraph 89 of the judge's judgment. Properly construed, I'm taking it right at the bottom of the page, paragraph 89. Properly construed, the phrase extra expense is intended to indicate no more than that the substituted course which has been undertaken has resulted in additional financial outlay which would not ordinarily have been incurred. And my Lord, if your Lordships then turn on 2 pages to page 243, at page paragraph 106 of the judgment, the judge says, in the context of Rule F, as I have held, all that is required is that the substituted expense which has been undertaken has resulted in additional financial outlay which would not ordinarily have been incurred. That is precisely what happened in this case.
He doesn't answer the question, ordinarily in what circumstances?
Well, my Lord, now I'm going to show your Lordships.
Do you disagree with the proposition that I think Lord Sumption put earlier, that if the expense is incurred, which wouldn't have been incurred but for the hijacking, that is additional expense?
My Lord, certainly that is additional expense, but there is learning on this, and I just want to show you what my learned friend was very careful not to show you, which is paragraph F20 in the current edition of Lowndes, which in many ways provides the answer to these questions. Now, your Lordships find that in Authorities Volume 1-2 at tab 22.
23?
22, and F20 is on page 1082. 1082. Internal numbering 190.
Sorry, which tab again?
I'm sorry, it's
22.
22. We have separate tabs, rule...
MS 1082, yes, page 190.
And the internal numbering, since my MS
internal
numbers are
numbering,
blotted
my
out.
lords, the
191.
it's 189.
190, sorry.
190,
Yes.
yes.
Yep. Yep.
Referring to Lord Justice Hoffman in the Bijela, he noted, and I'm going to read this, that the courses of action contemplated by the old Rule 10, that's forwarding of cargo and towage to destination, both fell outside the range of ship owners' contractual obligations. And then referring to the more generalised terms of Rule F, he noted, as the most recent standard work puts it, the substituted expense must be an alternative to, or in substitution for, what prima facie might be thought of as the normal or standard means of dealing with a given situation. What is less clear is whether all cases falling within F must exhibit all the features that I have identified in connection with those two cases. Is it necessary that the course of conduct giving rise to the substituted expense should have fallen outside the obligations contained in the contract of freightment, or is it sufficient that the expenditure was a less usual and more expensive way by which the owner complied with his contractual obligation, e.g. to repair the ship? Lowndes and Rudolph suggest that the expenditure of the latter kind would fall within the rule. And, my lords, so do we. We share the view of the present editors, set out below, that it is not necessary for the course of action to fall completely outside the contractual obligations. But, my lords, pausing there, this is not a question of contractual obligation. There is no contractual obligation to pay a ransom. In the context of the rule, an additional expense must be at least something that goes beyond the ordinary voyage expenses that might have been contemplated when the common adventure began. Those anticipated voyage expenses would normally include some element for contingencies, such as additional fuel during bad weather, may be enhanced by factors be outside the ship owner's control, but this is a commercial risk. The requirement to repair accidental damage to the ship and complete the voyage in a timely manner also remains part of the obligations, so that to qualify as additional, any expense incurred in this regard must involve something that is beyond the normal or standard means of conducting that repair. In practice, one is therefore left in some instances to decide questions on the basis of degree and impression. What is meant by extra, my lords, means an expenditure which goes beyond the sort of expenditure that you would ordinarily expect to have to meet in the contingencies of the voyage which may ordinarily be expected to occur.
Not including hijacking.
No, not including hijacking. So, my lords, it's
there's a difference between that and what Lord Justice Hoffman says, because he's talking about a comparison between the actual substitute expense and what prima facie might be thought of as being in the normal or standard means of dealing with a given situation.
Yes.
So in the present case, if you apply that, you would have to show that the normal or standard means of dealing with the hijack by pirates was paying 6 million immediately asked, and the substituted expense was a substitute for that, but that might be a bit difficult to show.
Yeah. My lord, may I just my lords, it might be helpful to look at this in Authorities 1.1, tab 9, where we have the full judgment. There is undoubtedly, my lords, a confusion here in Lord Justice Hoffman's judgment, in that he has just quoted from the relevant passage. I know it's bold of me to say so. He has just quoted at the bottom of, this is page 763 in the report.
Yes.
Just quoted from a passage in Lowndes and Rudolph, 11th edition, that the substituted expense must be an alternative. And then he treats that as a test not for the substituted expense, but for the course avoided.
Yes, I see.
And there are other...
Sorry, which was the passage on 763, right at the bottom?
Bottom right.
right at the bottom.
Yes.
Yeah.
Well, what actually seems to have happened is that Lowndes and Rudolph have changed their text, but rather cheekily applied Lord Justice Hoffman's words to the altered text instead of to the text that he had before him.
I haven't quite detected whether that is the case, but this passage is undoubtedly dealing with what is meant by extra or additional expense, that is to say, the quoted text. But then...
There's an inconsistency, though, in Lowndes and Rudolph's text, isn't there? Because at F20, one point they're talking about an additional expense being something going beyond the ordinary voyage expenses that might have been contemplated when the common adventure began.
Yes.
That's the opposite of Lord Justice Hoffman. But then lower down, they're talking about additional expenses. Any expenses must involve something that's beyond the normal or standard means of conducting the repair. In other words, that of reacting to the crisis. So they're
my Lord,
inconsistent.
In the ordinary... This is our air freight case, which we've looked at. The normal way, one has to determine, first of all, what is the normal way of carrying out a normal repair, which is a contingency one must be prepared to deal with as a ship owner. Now, these days, the normal way is to fly in spare parts, but it wasn't so in 1947 when the vessel we were concerned with in the Western Steamship case was under repair. So one does have to have regard to what's the normal way of dealing with the normal contingencies that might be pre-contemplated for the voyage.
Yep.
My lords, I can think of other examples, but what is absolutely clear is that paying off pirates or undertaking additional wages and bunker consumptions in order to negotiate with pirates is not part of the pre-contemplated contingencies of the voyage. Is there anything else that I need to say? Oh, my lords, the other, I suppose, one other element of extra expense that ought to be noticed is that one must look at the net position, because there may, in a case of substitution, be a saving of some voyage expenses pre-contemplated and an expenditure of others, and that's obviously the case in relation to towage or transshipment there. One must net off the position. Sorry. In bunkers, yes. A saving of bunkers if one is towed, but obviously the additional expenses of a tow. My lord, my learned friend has left me in a considerable quandary in knowing what to do about Rule C, because he has trailed it in his case, but not made any submissions in relation to the issues which your lordships have to decide by reference to Rule C. He's made no oral submissions about it. My lords, in my submission, it's a thoroughly bad point, but I'm not sure your lordships will wish to hear from me.
They both put their case in writing, we can forward that.
Yes. I think the course we'll take on that, given the time, is that you can put your submissions in writing.
My lord, I'll do that, yes.
And you can obviously send a copy, you'll obviously send a copy to Mr. Krell. How long will it take you?
My lord, I have something else I need to do this afternoon. So
it's all right, I wasn't suggesting, I was going to suggest a week. So that obviously...
One short point on Rule C. Rule C is about the consequences of general average acts.
But I mean, would your submissions consist in anything other than what you've already included in your printed case?
My lord, I put nothing in my printed case.
No, exactly.
I see, right.
Point. And my lord, I've seen my friend's document on the printed case. There is, I'm afraid I agree with almost none of it. And in particular, I don't agree with footnote 1.
Well, so far as he's dealt with things in his printed case that you haven't had a chance to deal with,
yes,
you can deal with them in writing.
I'm grateful for that.
And you have a week for that. We'll send a copy to Mr. Crowell. I wouldn't encourage him to reply, but if there's anything that requires, in his view, reply, then he can produce it very promptly, and we'll see where we go.
Yeah.
But I rather doubt any of that will make a difference to the outcome of this appeal. It would be wrong for me to commit us on that.
It is nonetheless, I should say, a matter of some concern to us that every time we argue this case, it seems to be not only a different game, but on a different pitch with different...
No, that's
I
quite
think,
Sorry?
That's quite common around here.
Yes, well, there we go.
not unknown. I think we have that message.
Yes. My Lords, let me just make sure I have nothing further to say, but I think I don't. My Lords, those are my submissions.
Thank you very much indeed. We're very grateful to you both for your oral submissions. We're grateful for the written cases. We look forward to receiving concise written submissions on the points which we've discussed just now. Subject to that, then, we will consider our decision and let you know in due course what it is. For the moment, then, the court is adjourned. Thank you.
My Lords, I did wonder if it were possible just to say a word, unrelated to the appeal, but related to my Lord Clerk.
Yes.
Because it had been mentioned to me, and I was reminded...
Lord Clerk.
We're all conscious, perhaps in this court, that this is the last time I think my Lord Clerk was sitting on a shipping appeal. And I'm also conscious that along with my Lord Neuberger, there's a formal valedictory next week. So I will keep what I have to say very short in that context. But we did want to say a word or two from the bar. We're conscious that over the last 24 years, my Lord Clerk has provided an enormous contribution to the law, generally to shipping law, in various capacities. I'm commercial court judge, admiralty judge, court of appeal, and more recently the master of rolls, and then, of course, one of the first justices of this court. And certainly for those who practice in the world of maritime law, there's a particular legacy for which we're all grateful. It's been my good fortune to appear on a number of occasions before Lord Clerk, and recently, I know, in this court on 2 occasions. From the perspective of an advocate, it was always a pleasure to appear in front of Lord Clerk, so long as, of course, one was properly prepared for a thorough, courteous and good-humoured examination of your case. My Lord Clerk had a knack of identifying the nub of a case, usually very quickly, sometimes as an advocate terrifyingly quickly, and also had a striking ability in his judgments to make sure that he never overcomplicated matters, but never oversimplified them either, with the result of having a body of judgments which provided clarity, and to those who subsequently read them, we all felt a little bit wiser. That's all I wanted to say.
Well, thank you very much. I shall reserve my defence until the valedictory a week on Friday. Thank you very much.
My Lord, lest there be any doubt at all, I entirely share in my learned friend's comments, and it's a matter of some regret that one of the things to look forward to in practice at the bar, that is to say an appearance before your lordship, is unlikely to be something we will be able to look forward to in the future. It's always been a pleasure to appear before your lordship, and I've done so at all stages of your career, including against your lordship in the Icarian Reefer, which your lordship may wish to forget about. But it's always been distinguished by great good humour and muscular intellectual curiosity, and it's been great fun. Thank you very much.
Very nice. My Lord says time to go home.
Yes.
Thank you very much. That was very nice of you. Thank you. Court's now adjourned.